Ottoman, Elliott, and Paul Dumont, if you all want to come up to the table at the same time. Good morning.
Morning.
Morning. And feel free to start anytime you're ready.
Okay, thank you.
Excellent, thank you.
Good morning, committee members and city staff. My name is Kim Savage. I'm an attorney in private practice. In 2003, I was hired by the City of Los Angeles as a consultant to undertake an analysis of the city's zoning code with a specific view of looking at how the city's land use and zoning code impedes the development, siting, and use of housing for people with disabilities. This was a 2-year study, and I submitted it for the committee on February 5th, so it is available for you to look at. At the end of that study, which made recommendations for amending the city's zoning code to comply with fair housing laws, a working team of city staff and myself was put together to review the report, develop amendments to the city's zoning code to eliminate the fair housing violations. And just for a bit of history, I want to let you know who this working group was, because I believe when you hear who it is, you will realize the significance of this work that was done. Jerry Burge, who city attorney for 29 years and head of land use. Jane Blumenfeld, principal planner. Suzette Flynn, who is still with the housing department and was with the policy section. We also had senior management staff from the Department of Building and Safety. And through a year-long process of meeting, we, among other things, revised the definition of family. So this is, what you see in your zoning code now is not an old, outdated definition. It was a definition that was crafted to comply with fair housing laws and the privacy rights under California law. This was a very deliberate process. It brought a lot of minds together with different perspectives. Can I just finish?
Yeah.
Thank you very much. Okay. So this current definition does comply with fair housing laws, and any revisions of it would, I believe, make it suspect under fair housing laws. Thank you.
Great. Thank you very much. Good morning.
Good morning. I'm Autumn Elliott from Disability Rights California, which is the state of California's federal and state mandated protection and advocacy agency for people with disabilities. The focus of today's meeting, as I understand it, is to talk about definitions. And the definitions that have been looked at in the past with respect to these issues, things like the definition of family, the definition of single housekeeping unit, they go to the heart of how people order their intimate personal lives, how they relate to the people that they live with. And so the more restrictive those definitions are, the more power Department of Building and Safety and other city officials have to go into a household and say, you can't live like this, you've got to change it, you've got to disperse, you've got to leave. But that does give the city the power to shut down housing that it wants to shut down, but it also restricts the way that folks in Los Angeles are able to live. And it, from a legal perspective, it hits at people's constitutional privacy rights, as well as, to the extent that certain ways of ordering your personal life are relied on by people with disabilities or other protected groups, it implicates for housing issues. Those are the legal aspects, but also just from a policy point of view, the city would do well to be very careful when restricting the way that people can live and the way that they can order those very personal aspects of their lives. Thank you.
Well said. Thank you very much. Paul?
Good morning. My name is Paul Dumont. I'm a volunteer housing advocate for the Sober Living Network. Last night, over 6,000 people slept in our member homes in Southern California. These are people striving to turn their lives around who agreed to abstain from the use of drugs and alcohol. They are a protected disabled class under fair housing laws. It is estimated over 49,000 low-income and disadvantaged people share housing in Los Angeles. A disproportionate number are racial and ethnic minorities, also covered by fair housing protections. They need more options, not more restrictions. Efforts to move these people out of residential zones in our city is nothing new. In 1985, the City Council passed an occupancy limit law that drew the ire of many of the same groups that comprise the Stop CCFO coalition. And the reasoning of proponents was the same: preserving single-family neighborhoods, relieving overcrowded conditions, parking, noise, health and safety, deteriorating neighborhoods, etc. The supporters of that ordinance were predominantly Granada Hills and Pacific Palisades, the same communities supporting this effort. And those areas are disproportionately white compared to the rest of Los Angeles. Wealthy white neighborhoods want only white tenants in their white communities. Such discriminatory motives still exist today. That occupancy limit law from 1985 passed, but it was later repealed. It allowed up to 11 occupants in a 3-bedroom home, 6 in a 1-bedroom, in accordance with state building codes. Imposing more restrictive occupancy standards against housing favored by protected classes runs afoul of fair housing law, particularly if the restrictions are because of the occupant's disability. The intended effect of this effort is illegal under fair housing law. Other cities have attempted similar ordinances that have been deemed unconstitutional. For example, just yesterday, the full Ninth Circuit Court of Appeals refused to disturb a decision by a panel led by the Chief Justice, which found Newport Beach discriminated against people in recovery. May I finish?
Yes, please.
With a land use ordinance nearly identical to LA's prior draft. The Ninth Circuit is allowing claims by the operators against Newport for reimbursement of marketing expenses to counter the city's negative publicity against sober living homes. In another case, the city of San Jacinto is negotiating settlement of a lawsuit brought by the Civil Rights Section of the United States Department of Justice because the council members there impermissibly restricted the ability of group homes for people with disabilities to operate within the city. The city of LA is going down the same path. We are not without valid solutions to neighborhood concerns about problem properties. The Sober Living Network and all members of the Stop CCFO coalition stand ready to work with you to eliminate nuisance homes with effective enforcement of existing laws. Simply moving people around with land use regulations runs counter to our goal of increasing housing opportunities for everyone in their community of choice. Attorneys from DOJ and Department...
Just wrap it up.
Yeah, one more sentence.
Sure.
Attorneys from DOJ and the Department of Housing and Urban Development told me simply to stop trying to help you craft a law that is barely legal, and that they stand ready to take action if you pass laws that impede fair housing choice. I suggest you govern yourselves accordingly.
Excellent. Thank you very much, all three of you. Appreciate it. And everybody else that showed up to participate and listen in as well. With that, we are going to go ahead and ask the Planning Department to come up. We are going to spend the time talking about definitions. One of the things that in taking the speaker's comments into consideration, this is, we've gone through the history, the laws. We spent quite a deal of time talking about the issues we've got in terms of enforcement and why they don't work here in Los Angeles without updating definitions, and looking at carefully crafting fair, equitable, reasonable, legal definitions that comply with both state law, legislatively, what's been enacted in other cities and what has been tested and tried in the courts as well. To be more inclusive is our goal, to be and ensure that fair housing and all the laws, all of the discrimination laws and issues pertaining to equal and fair housing for all are absolutely upheld in anything that comes out of this committee, should we decide to move forward with updating any definition. So with that, good morning. If you can walk us through your presentation and talk about some of the definitions in history, and particularly as it relates to the discussion pertaining to what a family unit is and where are we at, and as opposed to what other best practices have been out there.
Good morning, members of the committee. My name is Alan Bell, Planning Department staff, and with me is Matt Glesney, also with the Planning Department. So the public testimony was correct in terms of the update to the definition of family prior to the council's update of that definition. We had a definition that said it was limited to persons who were related by blood or by marriage. And I think that there was a limit to define persons who would constitute a family. So clearly, our definition in 2006 was not consistent with fair housing laws, the right to privacy, or the Adamson case, which said that unrelated individuals, if they constitute a single housekeeping unit, can qualify as a family. The issue, I think, that the planning department, I think that the council has been grappling with is when council updated the definition of family, we also had at the same time a definition of a boarding or rooming house. Now, this is a term that's been around for 5 decades. It's a very antique term. We typically don't have boarding or rooming houses built as new construction in the city, but it is use of land, and it is prohibited as a use of land in the R1 and the R2 zone. So the definition, the new definition in 2006 of family, there's a bit of overlap between that definition and a boarding house. It's not clear what the distinction is. It's really actually kind of a muddle if you look at both of those terms. And this lack of clarity, this amount of ambiguity makes enforcement very challenging. So I think that the definitions, that's a very critical issue, certainly to address, but I think it's very important to understand what the policy is. And then once we have direction in terms of what the policy is that the council wants to address, then we can draft definitions that would align with that particular policy. So the planning department, when we approached this particular assignment, we took as a given that the policy was that boarding and rooming houses, as defined, are not allowed in R1 and R2, that was inconsistent with the character and the zoning principles behind single-family zoning. So we took that as a given. So our charge was to make sure that we had an enforceable definition, and we made a clear distinction, an enforceable distinction between a boarding or rooming house and a family, so that when the enforcement agencies, building and safety, the city attorney's office, if it got to that particular level, that they would be able to clearly say that this is a boarding house and not a family, and so therefore we could then take enforcement action. And I think the consensus from the enforcement agencies is we don't have that clarity under today's code, and that therefore that hamstrings our enforcement options. So I think that since we're having a fresh start, we can certainly revisit the policy objectives. I think that there are different ways to get at the issue of what is the best use of this residential land that is zone R1. I think it's important to have that particular conversation. But I think that to make sure that we're not going to have the tail wagging the dog, that we need to have a better understanding about what our objectives are and what our policies are, so that if we're going to be revising those definitions, it's going to be consistent with whatever that policy framework is. So with that, I'll turn it over to Matt to go over more the details in terms of those existing definitions and then the proposed definitions, and then compare and contrast those definitions, and then what the intent was of what the proposal was and what was the revised definition was trying to do.
And while we're on that, and I think this is good, I just want to throw out there one thing, that should we, as we're exploring this and looking at different opportunities and definitions for enforcement purposes, on the same side, on an equal footing, and we'll have another discussion following up on the definitions, is if in fact, whether it's current definitions that we utilize for enforcement and or updating definitions, and that's whichever direction we go in, we also have to come up with and strike a balance to allow these facilities in R1 and R2 in a process that's efficient, affordable for them to follow in terms of allowing them to operate and ensuring that they are protected from that perspective as well. And if it's some type of permitting, whether it's, I won't even get into the details of what those possibilities could be, because they could be current processes we already have in place or creating some new one. And that will be open for discussion. But in terms of this direction, and particularly listening to the speakers' perspectives and certainly knowing a lot about the subject matter and hearing the interest on all sides of this, it is a citywide issue, not just in two communities and not just in any particular type of community by race, color, creed, sexual orientation, or otherwise. These are issues that are in every community in the city, not just the city of Los Angeles, but the entire region in the state of California that are dealing with an overproliferation of these, what I will call unscrupulous, if you will, operators that are operating businesses. And we want to also protect those people who are being housed or warehoused in these facilities. So with those definitions in mind and keeping in mind the spirit of which we're moving forward, I think it's important to always state those objectives. But if you could, just do a deep dive into some of your history and the definitions as well.
Sure. Matt Glesney, City Planning. I think we'll walk through the existing definitions on the record and then what was proposed as of January last year when this ordinance went to City Council. Just as a starting point, we understand we are starting fresh, but we thought just to, be important to sort of point out where we left off as a sort of a starting point where we could talk about what we liked, what we didn't like. But as Alan mentioned, really why we're talking about definitions here and the definition of family and how do these relate to problematic residences, however that is defined, is really the definition of family defines in our zoning code who can live in a dwelling unit. Our definition of dwelling unit says you have to be a family. And so so if you are a family, if you met the definition of family under today's zoning code, you are allowed to live anywhere anybody's allowed to take up residence in a residential zone. And so that's the power. That's where the muddle, as Ellen alluded to, comes between what is a family and what is other types of uses, a boarding house, an apartment hotel, a guest house, et cetera. They all sort of say you're a family or you're something else.
And to be clear, does the state statute, it doesn't define family, it just refers to family and the locals are to interpret that. Is that correct? Yeah,
I could not find a state definition for family or single housekeeping unit. I did look and I couldn't find that. They do define certain things like boarding house, and I could talk about that, but they do leave it to the locals to define families. So what we have on the books today, as was mentioned, was crafted in 2006 as a result of concerns that we were out of compliance with fair housing, that we hadn't reflected case law and fair housing legislation. And so we created a definition, as I believe you have in front of you, that talks about a family simply being two things, really. You are a group of folks who are living together in a dwelling unit with common access to and common use of living, kitchen, and eating areas. So, one of the things we did is we took a look at a lot of different cities' definitions of families across the state, even outside of state lines. I think it's fair to say that this definition is on the more permissive side statewide, and that was a decision made in 2006. That again, you just need to have. You could be rooms. You just have to have access to these common areas, the kitchen and the living rooms. Some cities go further than that in trying to define what is a functional family unit, and that's sort of the legal standard. And I'm not going to get too much into the case law, but the Adamson case versus Santa Barbara in 1980 tried to define what makes a group of unrelated individuals a family and therefore protected. And really, it's this idea that they're a functional unit. And they share responsibilities. There were a lot of things that they cited that this group in Santa Barbara of 12 folks, they constituted a functional family, even though they weren't a traditional family. They weren't related. They were unrelated folks. And so I can go through there's a lot of different options I can go through. But what we landed in the end of in January last year was adding a number of provisions to the definition of family. Number one, I think, is that it would be a non-transient group. If you look at I'm just going to highlight, I think, what are the distinctions between the old and the new. It would be a non-transient, interactive group. So it's a group that has some sort of consistency, some sort of permanency. I believe transiency is somewhat defined in our code as in a different ordinance as being 30 days. We have a use called a transient residential occupancy. And so that if you want to know kind of what that would mean. So the idea is it's somewhat permanent. And they're interactive with each other. They're not people that don't interact with one another. They interact with one another. They have, I think the second distinction is they would share household activities and responsibilities, such as meals, chores, expenses, and maintenance. And that is something, again, I think you see fairly common. I think both of these are things that you do see in a lot and fairly common in a lot of cities' definitions of families, these kind of additions. The final provision is probably been the most controversial, I think it's fair to say, and that would be the idea that the makeup of the members of the family is not chosen by the landlord or property manager or third party. It's actually the members of the household of the family is chosen by the members of the unit themselves. And the rationale there was, again, to try to draw a distinction, try to say, when do you cross the line of really not being dysfunctional family that's been described in the court, say a household unit? Are you a household unit if somebody else is choosing who's part of your unit? If someone else is making those decisions. And so I think that was part of the thinking behind that. But certainly that is what's been highlighted, I believe, as potentially causing concerns in terms of limiting housing choices for people with disabilities, as well as just the greater shared housing, group housing kind of situations that many Angelenos live in, just sort of roommates, shared housing, however you want to define it, where folks are sort of, they can't afford a whole bedroom or whole unit. They're renting a room in a house, and they don't have a choice of who sort of comes into them. And so that was the intent there, but there obviously is policy considerations. I think that's the part of the family definition that's drawn the most attention and potentially would cause the greatest impact. So I think we'll maybe just stop there in terms of digesting where we were, what the proposal was.
Yeah, so I've got a couple of questions. So you mentioned 2006 a couple of times. Is that the last time that we changed the definition of family?
Yes, it was.
And what was the impetus for changing the definition at that point?
It was really a result, as Ms. Savage said, really there was this sort of statewide effort to identify zoning codes that may be potentially out of line with current state law and fair housing law and in court cases, and the feeling was that our previous definition, because it had language about related people, it had also a number limit on unrelated people, and that those provisions particularly were seen as being potentially in violation of fair housing. And so the idea was to remove that and go with what is sort of the current standard under the courts and privacy law and fair housing law in terms of stripping away a number limit and the blood relation limit, I think, was the main impetus of changing.
Got it. And I'm going to really just simplify the conversation, understanding for those who are listening that it's not my impression that a family constitutes only members of the same sort of bloodline, but just for the matter of this example so I understand. So the residential care facility statute says that 6 or less should be treated like a family. If we were to change the definition as proposed to what you just sort of rattled off, those 3 elements of housekeeping, non-transient, and the third element, which is the sort of the selection of who's in that quote-unquote family, would the folks then in the statute then have essentially more protection because of they're seen as more of a quote-unquote sort of family? I guess what I'm getting at is that seems, to me at least, at first blush, it seems like this definition would be of little to no impact to those to the statute for those facilities of 6 or less. I mean, it seems like that, and I don't know sort of where the problem is, because they're afforded this sort of protection as our definition. It would beg, though, the following question of us being able to create a definition that would accommodate those folks who don't self-select. A nonprofit organization, for example, that says we're going to provide shared housing for a certain constituency, and that constituency doesn't have the ability to select who the members of that quote-unquote family are. we would then have to set up a definition to accommodate that situation. I'm just trying to bifurcate sort of, or can we check the box and say that we're in compliance with the statute and we're affording a lot of protection there, and then what other definition would we have to create to make sure that we allow for shared housing where you have nonprofits or some sort of communal arrangement? Because to me that seems like that's okay to do, provided we create that second definition, but I'm just wondering out loud if that's rife with peril here in any way.
And if I could on that, and that maybe that'll bleed into the discussion of what is a boarding home versus what is a...
Yeah, I'm nervous about talking about sort of things that are already statutorily defined either by ordinance or by the state, and it was alluded to that at the state there's some definitions and the city has some here. I'm just, before we sort of get there, would we be affording this constituency, not tremendous, but real protection if we change the family definition as proposed?
Councilmember.
Specifically because of that third element where the self-selection, to me, I can understand why that would make folks nervous, but to me it seems like it really offers it really strengthens the intent of the statute potentially, and I'm just wondering if that's...
I think the answer is fairly simple, council members. So for licensed facilities, meaning they're licensed by the state of California and they're serving 6 or fewer residents, regardless of what definition we might adopt in our local zoning code for family, it would not impact their rights because they are completely exempt under state law from local zoning controls. So they have that state protection under the Community Care Facilities Act if they are licensed by the state of California by the Department of Social Services. So if the council adopts a definition of family that is more restrictive than what is on the books today, that calls into question a whole host of other questions related to group housing arrangements, shared housing arrangements, but they are not licensed by the state as a licensed community care facility, but they are shared housing arrangements. Sometimes in other communities and they have what they call community residences, which are not defined as a boarding house. It's not defined as a family. It's not defined as a licensed facility, but it acknowledges shared housing, particularly shared housing for people with disabilities.
So let me see if I can put a finer point on it. So the statute says that this class of folks that are being served in licensed state facilities of 6 or under should be treated as families. If we update our definition of family, do we then transform that constituency and afford them additional protection under this new definition? You say that they're completely exempt, right, which begs a question. If we're not transforming and recognizing them as quote-unquote families under this new definition, do we then have to set up a new definition to accommodate those state-licensed 6 or fewer locations?
No, we do not. Because if they're licensed, they're not if they're licensed by the state and they serve 6 or fewer residents, they simply do not have to comply with local zoning, only to the extent that they are allowed in any zone where we allow residential uses. So we wouldn't allow them, for example, in an industrial zone because we don't allow residential in an industrially zoned property.
And what we could do is, if we go in that direction and look at updated definitions or modifying their current 2006 definitions, if that's the direction we go in, we can also note and add or footnote the state's definition under the licensed facilities, and that we recognize that as well.
Yeah. No, I don't want to add more. I just want to sort of understand whether there's a transformation that happens to this class, because in my mind that affords them, if they're quote-unquote to be treated like families, then we're affording them additional protections, right, which makes me feel good. But again, it necessitates us having to really create a definition for those unlicensed sort of operations, which is, I guess, where we're going to next. But I just sort of wanted to stop, right, and understand that very well. Thank you.
We had, council members, we had originally thought about including definitions that would mimic the state code for these licensed community care facilities serving 6 or fewer, the state codes are extremely complex, and we kept running into a situation where we didn't capture everything at the state level. Sometimes the state law will change, so we felt it would be more prudent and offer greater protection for these facilities if we were silent in our local code. And then we can provide guidelines or technical bulletins to people at our counters to say you are in fact covered under state law, and so therefore you're not subject to local zoning. So we found it very, very challenging to create a definition that wouldn't create more problems actually than we intended to. So we felt at the end of the day it would be better to be silent on that matter and just simply defer to the state preemption.
So just for clarity, this proposed definition, we would, as it relates to state licensed 6 or fewer, I'm sorry, I just want to make sure I got your attention. For our purposes, as it relates to the state licensed 6 or fewer locations, this proposed definition wouldn't have an impact on that because of the exemption.
Correct.
It would, though, define again, just to simplify things, living relationships that are probably not operated by a business or a nonprofit.
Well, I think
unless their model says that, you know, folks are in a pool and there's a shared housing thing and you can select who you live with, but I mean that seems to be a real rare exception. So this is really intended to, again, and not to simplify things, or to overly simplify things. It's really intended to address sort of the whatever traditional means family living arrangements because of the third item there where folks have to self-select who is in that housekeeping unit.
And, you know, as Matt pointed out, that is an unusual feature, the self-selecting feature. That's not a common feature that we see in definitions of family in other municipalities. At the time, we believed that the self-select feature was important, that it more mimicked how a more traditional single housekeeping unit would come together.
I just want to make sure that I understand sort of where we are, because the next sort of definitions are going to be really important to see if that will work, because otherwise it could be a very exclusionary sort of thing that we're attempting. So I understand it. So now I guess on to the next part here. For those 6 or fewer that are not state licensed facilities, what definitions would we create there?
Well, and it wouldn't necessarily just be limited to 6 or fewer, because the 6 or fewer conversation or the 7 or more conversation, that only connects to licensed facilities. So unlicensed facilities, group housing arrangements, regardless of the number, we don't have definitions that speak to that housing arrangement. That's not in our current zoning code. That's not in the proposed definitions here. So there might be an opportunity to create some new definitions that would align more along the lines of other communities have defined these kinds of shared housing arrangements, and I know that Matt has done some research on that.
Okay, I think with that, and I'm looking at the analysis of impediments to fair housing choice. This was the report that was done in January 2006 that I just pulled up. For those of you who are following along, this is the report that was referred to earlier. It's quite comprehensive. It really did a great job of articulating all the issues and concerns, the legalities, and making sure that and if you haven't read it, and I would ask people that they do, in fact, if we could post it as part of the council file number as well. So we have it readily accessible to everyone, because anything that comes out of this committee, we're going to ensure that this is a foundation that we look at. This is a very well done report to make sure that we are absolutely inclusive and fair. This was done out of the Los Angeles Housing Department, actually commissioned this report, and I think what they did was a great job in looking at all the federal issues and the state issues, and addressing some of the definition issues as well in this. So refer to that report. In terms of the next committee meeting, what I would like to do is ask for a written report at this point and a matrix of all the different municipalities that we've looked at for definitions. And I would include the community residents that you brought up on shared housing. I would include in that report the current definitions we have for family, single housekeeping units, boarding or rooming house, proposed language, but also showing what other cities are using. And so we can look at that and see what are, and start having a deeper discussion on what are some of the other definitions that other cities are utilizing and using, and what may or may not make sense here.
I think that's absolutely worthwhile at some point, but I just want to be clear about sort of this proceeding here. I couldn't be supportive of that third element of the family definition unless we had conversations about sort of what follows in terms of allowing for shared housing. So it sounds like you're talking about the next agenda. I'm not sure that we're finished with this one here. I'm just wondering sort of, if we don't have time to do it, I understand, but what other sort of proposed definitions, without having to go into sort of the definition, are you sort of seeing that would help get us through this? Because the reason I'm being so, I think, careful and slow about 6 licensed, 6 unlicensed is that I would need to understand the 3 or 4 different definitions, maybe 10, maybe 2, that we'd have to come up with to understand how to accommodate everything that we're trying to talk about here. And I'm a little leery about talking about the next agenda without sort of finishing this one.
Well, I think this is, I want to continue the discussion.
Sure.
And broaden it to include this particular issue should be included. In other words, on the next agenda, we should have the current family definition as well as the previous proposed, and dissect it just based on your input, which I think is critically important. And with that, though, and which is why I asked on the next agenda to start looking at, and I heard some of those concerns loud and clear, which is why I think we should ask for what are some of the other definitions other cities and counties are using to have the discussion of, and so we continue this discussion. We don't put it behind us, and it's not completed at all. In fact, I think what we do is, based on the discussion today and what we heard, is we actually spend more time on it, not less time. And so we take that, we keep that alive on the next agenda, and hope for more participation. And I know the other committee members could not make it, but that's why I want to have a lively discussion with all of them here. And I think we need to revisit that particular area, particularly as it pertains to that last area that you had some concerns with, and I too have some concerns with, and maybe there's better ways to look at that issue, which is why I want to spend some quality time on it.
Yeah, I don't know that there's better. I think there's a continuum here. I think that would work, provided that we have, other accommodations in ordinances. So I just wanted to be clear that I don't think that we've ended the conversation,
Right.
although
Yeah,
it
not
sounds
at
like
all.
we're ending the meeting.
Nowhere near ended
Okay.
the conversation. And then,
Well, at some point we should land the plane, though.
well,
I mean, it's,
this is a big plane to land. One of the things that we will bring in, not in the next meeting, but probably soon after, is some proposed. I don't think we lock in on any language yet. We're going to start having. We'll bring that back home after we have. I want to do some community input meetings as well, which we've discussed, and I want to ensure that we have more participation. We've also had the idea of doing some off-site meetings of this particular ad hoc meeting throughout the city, and so we can get some participation as well. But in the future meeting, maybe the next 2 or 3 meetings down the road, some proposed flow charts on what would happen, so we can actually visualize, if you're state licensed, this is what happens, and easy to read, easy to follow. If you're not, here's what happens. If you don't fall into whatever definitions we land on, whether it's the current ones we have or modified, whatever that might be, and you're not licensed facility and you are operating under as a facility and not a family or housekeeping unit or however we define those, what ability then do you have to get permitted? Can you come through the city? And we don't have to fill in those boxes as of yet to label those of what they might be, whether it's conditional use permit or a variance, or those are things that we've already, I won't say excluded or ruled out completely, but we have issues or concerns with because of the time and the cost, and we want to make sure that Also can look at boxes of reasonable accommodations and where would those fall into, so we can have a clear understanding and a roadmap that we want to provide housing here in Los Angeles, and make it easy and accessible for people to understand how they can go about, if they can't or aren't able to fall into the definition under state law to get state licensed, then how do they operate here and in what type of zones? And if they can't just by right, then what kind of path can they choose or go down to make it easy and efficient and affordable and legal to do so? And I think that's the direction I'd like to go in, is ultimately end up with a flow chart for people to understand and for us to understand and the planning department to understand and the building and safety department to understand exactly how we can provide more opportunities. So with that, we'll go ahead and ask if you can come back to the next meeting with a written report on best practices, other definitions with other cities. I know you've already done a lot of that work already. We'll be resubmitting it to this committee for consideration so we can just start going through and examining some of the other language that other cities have already looked at. Anything else you want to add for the next discussion or meeting? Terrific. Then that'll conclude this meeting, and we are adjourned. Thank you all.